Good morning. I'm Mark Kimball. Agenda item 1 is the call to order. It's 10 a.m. on October 23rd, 2025. I call this meeting of the Citizens Clean Elections Commission to order. With that, we'll take attendance. Commissioners, please identify yourselves for the record.
Commissioner Werther,
Galen Payton.
Sam Crump.
And I'm Mark Kimball. We have 4 of the 5 commission members present, so we have a quorum. Item 2, discussion possible action on minutes for 3 meetings on August 28th, September 25th, and October 7th. Commissioners, you have the minutes, from our past 3 meetings in your packets. Is there any discussion? Hearing none, we'll vote on We'll vote on all of these in one motion. Is there a motion to approve the minutes for the meetings of August 28th, September 25th, and October 7th?
Mr. Chairman, I move to approve the meeting minutes for August 28th, September 25th, and October 7th, 2025.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we approve the minutes for our meetings on August 28th, September 25th, and October 7th. I will call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump.
Aye.
Chair votes aye. The minutes for those 3 meetings are approved. Item 3, discussion possible action on the executive director's report. Tom?
Yes, thank you, Mr. Chairman, members. I just wanted to highlight a few things. I think one thing that is, is interesting and unclear what the ramifications will be, but you may recall from 2024 there was the No Labels Party, which is a new party that circulated petitions to get access to the ballot. They are eligible for the ballot this election cycle. Last week they renamed themselves the Arizona Independent Party. They have, according to the news reports that are cited there, they have some more organization than they had at the local level, and appear to be interested in having candidates at the state level potentially. The reason I highlight it is because they're a party, so they'd be the candidate who ran as an Arizona Independent Party member would be eligible for clean funding if they wanted to do that. So we'll see how that happens. Smaller parties have not generally, maybe once, twice, maybe really made an effort to qualify for funding, but so it really kind of depends on their organization and what they're trying to do. But I thought it was worth highlighting. I think the other thing worth highlighting is, we have a general election on November 4th. There are local jurisdictions that have elections happening. All that information is available on our website, and the illustration comes out a little small, but I just wanted to it sort of illustrates that I'm not yet the graphic design genius I hope to become at some point. But essentially, the November 4th elections, we get a strong with a person from the West Valley who wanted to find out more about there's a current technical district out there that is doing a bond issue and doing a sale of some property, and so we spent a little bit of time trying to find some information on that. So I think that's important, again, because for these smaller elections, folks, they don't get the publicity that they otherwise would, and having a central hub for that's very important. And Alec spends a considerable amount of time. I would say that's actually why he's working on that as we speak at home, making sure that the website's up to date. So we are continuing with the podcast, and we highlighted the elections, these elections on the podcast. I also just really liked this interview we did with Dr. Prado from Arizona State about the fiscal challenges of the U.S. If you haven't had a chance to listen to it, it's not uplifting, but it's interesting. And we think that we will have some metrics as we get to the end of the year, but that we think that is also, again, trying to build out, places where if someone comes to the Clean Elections website, they can find information on something that's relevant to them, that's going to get them engaged, and ultimately, hopefully, help them to vote informed. A couple other things I wanted to highlight on it, just the um, uh, uh, and, Avery and Captain Activate were out in Tempe last week, and I have seen some photos from that. I need to hopefully we can circulate those to you. But it was a great event, and that it was with the Tempe clerk's office at the city hall, and really well attended, and the photos are great. There's a picture of Captain Activate and the mayor of Tempe, so I thought that was pretty cool. Tomorrow, Gina will be presenting, one of the main presenters at the Strategic Partnerships for Arizona Elections, which is a discussion among tribal governments, county governments, and state government officials around, election issues for 2026. And I think it's a really a great recognition that that she'll be there talking to them about voter education, as in and as her featured as their speaker on that topic for the whole group, which I thought was really cool. I think the only other on the Prop 211 matters, I think we haven't had a real chance to talk about this. There's not too much to talk about except that there's still one case pending at the state Supreme Court. There is one case pending at the Ninth Circuit, and then the result of the opinion that came out last month from the state Supreme Court is that the legislature will have an opportunity to pursue on the merits its claim that Prop 211 violates separation of powers issues, sort of broadly speaking. As you can see there'll be a conference on that next week with the attorneys. So we'll see where that goes. I think it. We highlighted a couple of other cases here. I don't know unless you have specific questions on those. I mean, just under other legal issues. Just to say that as we get closer to 2026, there are going to be a bunch more decisions around how elections are administrated. Most of those are not going to directly affect us. Even the case I mentioned on the sort of last page about the which is where the Supreme Court's looking at the federal law restricting party coordination with federal candidates. That in Arizona, that's already the current policy in Arizona is that parties can in fact coordinate with their candidates. So it's not an issue here, but I think that they're the kind of things that I think affect voters and voters call about, and we want to be aware of them for sure. I guess that's about it that I felt like I needed to highlight. But I think we're all pretty busy, and hopefully we'll finish the year strong, and next year will be very exciting.
Tom, if I could go back to the first item, No Labels Party, now called the Arizona Independent Party. I guess parties can call themselves whatever they want, but this seems like it will confuse people. Commissioner Werther and I are registered independents. We're not members of the independent party, though.
Right. I think, Mr. Chairman, I think that's true. And I think, we will, and as part, I'm sure that as part of our voter education effort this next year, that's something we're going to have to address. How we choose to do that tactically, I don't know. And I think that's going to be an issue also for county election officials as well. That's something we'll probably be in communication with them about, because you're exactly right. Now, for a primary, unless they were to close their primary, you could select the Arizona Independent Party as your party. And I think that, that may be part of what their goal would be to folks but that still would require you to select it. I mean, otherwise, so, yeah, that'll be interesting. I don't know. I don't think this has gotten enough attention yet in the real world to generate those questions at any volume yet, but that will be an issue. We have a meeting that we'll attend next week with the counties and the Secretary of State's office about, among other things. I mean, so long story short, you're right, and we'll be looking at that. I don't know the process by which they changed the name. It's I think you're right. I guess you're right, because I didn't know about that before it happened.
Well, it seems designed to,
Yeah, it seems intentional.
yeah, to cause confusion.
Right.
I mean,
But I guess people can call themselves whatever they want, but.
right.
Are there any other questions or comments?
they're-
from
they're
members?
just-
Mr. Commissioner Payton?
Maybe they're trying to, through the confusion, hopefully they can sign more people up, basically. Yeah.
Mr. Chairman,
Why else
yeah.
would you do it, I guess?
Well, if you're, I mean, Mr. Chairman, Commissioner Payton, I think that, as the story, the coverage sort of sets it up that, yes, they see themselves as a party, as a place for people who are not members of the Democratic and Republican Party. I think the confusion point to both of your points, one of them will be regular folks who are currently independent saying, am I now a part of this party? In the primary, that shouldn't be a big deal, because they could request that ballot, but they may be surprised with what they get, right? So that's part of it. I mean, so it's a real issue. I mean, don't get me wrong, it is, but we just don't. I don't think we've had enough discussion with our colleagues out there in the administering voter registration to understand, how they see it and what steps might be taken to mitigate that.
So is this an issue for the Secretary of State then?
Well, insofar as Mr. Chairman, Commissioner Payton, the Secretary of State approved the name change.
Okay.
So I don't think whether it's an issue for them implementing it or not, I suspect they don't have a lot of discretion around what they get to do in that context.
Any other questions or comments from members of the commission?
Mr.
Commissioner
Chairman,
Werther?
just Tom, also, I guess I also see confusion the other way,
Yeah.
in that you may have someone who is currently a member of a registered party who no longer wants to be affiliated, but thinks that they're signing up to just be party not designated, but they're inadvertently becoming
Right.
part of the independent party. So just to think about that.
No, I think that's a good point. What we've done with some things like this is and Gina's in Maricopa right now is done a chart or a click through tool to figure out where you are. That might be something we do. I mean, something visual, something easy to grasp that will, tell people where they are, based on, my voter registration card says X, or here's where I am. If I want to be here, I need to do this. If I want to stay here, I need to do this, that kind of thing.
Well,
So,
I don't want to prolong this, but every year during the election, during the primaries, we were bombarded. I'm an independent. Can I vote in the primary? And it's a lot of confusion. And I think this is just going to be one more point of confusion.
yeah, I think that we
Commissioner
may
Payton.
have to put something like some kind of notice out, before the next primary or something, saying, we don't want you to be confused. This is
Sure.
the situation. I don't know if we could do something to every independent
Well,
voter to
So-
explain.
Mr. Chairman, Commissioner Payton, that would be very expensive, and maybe not very effective, depending. But I think this is all good for me personally. In the meetings that Gina and I will be at about this. This is helpful for us to be able to say to, that you all have identified some of these issues, and that's so we'll see what feedback we get, and we'll keep an eye on it, and have and be able to, I think, be constructive. So I appreciate all the-
Because here you've got two people that are involved in elections
Right.
that would possibly be confused by it,
Right.
let alone the regular voter that's trying to live their life and whatever. And for whatever reason, they want to be independent.
Right.
Now they're not sure if they're part of this deal or not. And then, I mean, I think it's not good.
Are there any other comments or questions for Tom on the executive director's report? Thank you, Tom.
Oh, thank you.
Item 4, discussion and possible action on proposed amendment to Arizona Administrative Code R2-20-702, use of funds by candidates. In our discussions in the enforcement context and other rulemakings we have pending, we've discussed how to address issues with respect to perceived potential conflicts when a candidate hires a vendor with a particular relationship. Staff has a proposal on that issue. They are asking us to circulate for public comment. Staff also is asking us to address a technical issue in the way our rules are currently presented in the administrative code. Tom?
Thank you, Mr. Chairman, Commissioners. I think we have a little bit of a sort of a slide to try to illustrate for everybody what what we think the problem we're trying to address as core is. This is the current state of things. If you're a clean candidate, you can't use your clean money for personal expenses. So that's and then if we go to the next slide, I think is the problem we're trying to solve, which is a perception problem, but nevertheless a real one. There's a delay on the thing. I forgot. Well, it'll show us that the problem we're trying to solve is what happens if you share a household with a consultant, whether that's a spouse or any other or other person you share living expenses with, and how do we address that? As the memo details, we kind of talked about, and I know there was some discussion towards the end of our conversation last month around setting it as a percentage, and we're open to talking about that. The reason we kind of ended up going with sort of a black and white rule is because it's easier to administrate, and it's not clear to us that a percentage cutoff necessarily solves what the core of the problem is, which is basically taking the money out of, the potential perception that money from passing from one person to another person within the household would inevitably lead to some of those dollars supporting the household rather than the campaign. So that's why we settled on what we settled on. We also included in that rule, however, a proposal, you can still get reimbursed for things that are that'll reimburse. So if somebody goes and buys pens for an event, that's still going to be reimbursable, right? We're talking about we're talking about expenditures like campaign expenditures that are serious. And then there's also a provision in there that says if for some reason, and this could happen because some events in some areas, it's conceivable this could happen because in some areas, either because of where they are, the way the market is, what the particular item is, there may not be available competition. In other words, this may restrict folks in a way that is meaningful. And we wanted to at least account for that possibility. If say there are maybe two people who make 4x4 signs in the whole state, for example, and you happen to be in a relationship with one of them, or you wouldn't want to. I mean, that would be a real problem, and that you wouldn't want that to necessarily disqualify you, but you'd have to basically ask permission. I don't think it's likely, but at least it's to the point that I think came up around the percentage. It's a way of addressing the issue of not being overly of being clear without leaving no breathing room, essentially. If there was a circumstance that arose that met that requirement. We base that on the main statute. The main statute is basically says if you're a candidate or a candidate spouse, you can't pay yourself at all. And there is and that does bring in an issue we haven't directly addressed, which is specifically salaries, right? So there's this idea that has been out there to have, what happens as we do the analysis is sort of these issues as you start to intertwine, right? Is really, once you're talking about how the clean elections money is being utilized, you sort of get to some questions we haven't asked before. And we thought, well, maybe, or certainly I thought, I don't know if I'm speaking for we or not, but we may as well, just make that clear, that you could not pay yourself a salary out of clean elections dollars. There are arguments that you can do that with state dollars at the state level for candidates, and candidates at the county level have in fact done that with their own funds or their campaign funds. But I think that given where our policies are to begin with, it would be very difficult to square that with what the existing policies are. So that's kind of how we approach it. I'll highlight just briefly. There's this kind of formal and not unserious, but formal issue we haven't got completely, and I don't think we're going to ever get completely we're probably not going to effort to get the complete answer to. At some point, the subsection we're talking about disappeared from the published code, and we don't know precisely why. We may we may be able to figure that out, but it's not very important for present purposes, because the more important thing from our point of view is we need to update the rule anyways. We have some things we want to address, we think, or at least get feedback on. And so we'll have time in the meantime if we need to track that down further to do that, but because we're only asking for public comment at this point. But we did want to kind of flag that as a thing that exists. So that's kind of all I really had. I think that the goal here, like, just to restate, is just to try to get at the perception, whether it's real or not, that if you are in a position where, you are hiring a person with whom you share household expenses, or you're in a marriage with, or whatever, that that's a potential end run around not using clean elections money for personal use, and that's the core of what we want to do here. We also left in place the ability to hire and pay family members. That doesn't change outside of these provisions, right? So if your son is a campaign guru and you want to hire him, so long as you're not paying him above a market rate and that's disclosed, that's still going to be fine. It's really about, and that's again a way of making sure that we're not being overly overemphasizing. So and then I just would say that because Maine and our model, although they have more funding available for candidates than we do, are similar, developed at the same time, and basically by the same people. I mean, the fact that they have this in law, I thought was a pretty good indicator that it must be a decent, workable policy. So
initially, when we started talking about this seemed to be an easy fix. Like you can't pay family members or spouses or significant others or whatever. But the more we get into it, I think you've identified that it's not that clear cut. And so I think what you're proposing is a good compromise between appropriate spending and not disadvantaging candidates unfairly.
Yeah, I hope so.
Commissioner Payton?
So I'm not totally sure I'm clear on really what the difference is.
Sure.
So what I'm against is, I'm against is we give somebody $52,000
Right.
and they write a check for $48,000 to their significant other,
Right.
basically.
Yeah.
So are we just funding a lifestyle,
Right.
or are we funding the election matters of this person? And I understand it's hard to kind of pin down all these things, and then when you talk about market rate, I mean, is there a market rate in Benson, Arizona, or so
So
I'm not sure exactly what we're achieving here.
So no, Mr. Chairman, if I may, Commissioner Payton. Yeah. So the first issue, your immediate problem is directly solved, in our view, by section what'll be F5 of the rule that says that a candidate shall not use funds in the candidate campaign account to compensate the candidate's spouse, or a person with whom the candidate shares household expenses, or to pay an enterprise owned by such individuals. That's a black and white no. So if that transfer that you talked about, that $48,000 to the household, basically, that is forbidden. The only time that there would be an exception is in this rare case where there's no other person available that could do it, which they would have to prove. Other family members outside of the household would still be able to be paid at a standard ordinary rate, which is so what this rule does is it exactly, we think, meets what we think the issue that you've identified is. I mean, because what the factual scenario you identified is illegal under this rule. If your family member who is not a part of your household works for your campaign, that's different because of what the life, because of the living situation, and so the rule treats that differently. So that's so we think we're doing. We think we're addressing precisely the question you have.
So I don't want to get into minutia, but these people are going to come before us.
Right.
And so let's say your son
Right.
doesn't live with you.
Yeah.
He lives in North Tucson. I
Yeah.
live in East Tucson.
Sure.
I'm the candidate. Then I do a contract with him.
Yeah.
And say, we'll pay you $5,000 to do this, 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 and this.
Yeah.
Now, I mean, I would not be opposed to something like that.
Correct. And
But
that
then they'd have to do the contract or something
correct.
to explain what he's doing. It's just not a $5,000 check to Billy, Bob, and for
Correct.
election expenses.
That's correct. That is what this rule
Okay.
says.
Yeah, I'm fine with that. I'm the arbiter here, but
Well, you're an arbiter.
Mr. Chairman.
Excuse me, Commissioner Werther?
So Tom, I just wanted to kind of make sure that I understood how the rule was working. So under the new, I guess, F5.
Yeah.
So it's the candidate spouse, and the person with whom they share household expenses.
Right.
Kind of capture
Yeah.
any other individuals.
Right.
So that's the prohibition.
Right.
But then subsection B says, of course, that you have, I think it's kind of trying to note that current exception, right? About reimbursement
Right.
for reasonable expenses.
Yes.
And again, includes the same people, candidate spouse, and the
Yes.
person who's sort of living in the household.
Yes.
But I guess that's where I'm not sure, because are we only then kind of trying to reference F4, which is talking about sort of that fair market, as long as it's not exceeding fair market value?
But I'm sorry. Yes.
Oh, because that only applies to family members, and family member definition doesn't seem like that encompasses someone who lives in the household who is not a spouse.
So, Mr. Chairman, Commissioner Werther, I mean, we think that the notwithstanding clause at the beginning
Mhm.
says we don't care about what it says about family members in F5 if you're in these three buckets, regardless of family membership, because that also gets at the fact that we, if we the other way to do this, which I think would actually be more complicated, would be to get in and change the family member definition itself and start to try to include as family member a living expenses. So we thought it was simpler and cleaner to just say, okay, you're a family member X, Y, and Z, and then you go to, and then the next section says, forget all that. If you're in these buckets, which are not all family members, you are out as a person who can get paid. That's what we are trying to do.
Mr. Chairman, I have another question. Okay, I guess maybe then I'm confused by what 5B is trying to allow, because it says does not prohibit reimbursement to those individuals for reasonable expenses.
If you had a, I mean, we can make this clearer. But I mean, basically, you can get reimbursed for gas. You can get reimbursed for, I mean, there are express provisions of the rules that allow you to get reimbursed for those kinds of things, gas and going out and buying paper supplies and that kind of thing.
And Mr. Chairman, Tom, I guess, and that's not limited to, because like I said, I see F4, and that's only limited to family member, which would not include someone who is not the spouse who's just living, sharing expenses.
Correct.
So I just wanted to make sure that as we're doing this, that we're, I guess, treating everybody, you know what I mean? The same, if that exception exists,
Right.
that would a person who's just sharing living expenses, I guess, be eligible for reimbursement under the rules, or do all the other times where it discusses reimbursement only address family member, which would not include?
Well, the thought would be by notwithstanding F4, we're just the family member rule doesn't talk about reimbursement at all. It just talks about the sort of contract for campaign, expenses. So if you think about it, what we think the context is here for F4 is, I mean, there's a fine difference, I suppose, but I think it is a meaningful linguistic difference between payment and reimbursement. Payment for services versus reimbursing for expenses are not the same thing. At least under the way that our rules treat them, and certainly under the way that our auditors treat them. So, for example, if our auditors can look and say you reimburse for gas, that's going to be treated as a reimbursement. I mean, we didn't recapitulate the entire rule scheme here, and in terms of how every expense is accounted for between the here. But so you have to sort of, don't have to, but I'm urging you to take my word for it that we could tighten it, and I think that's fair game. But the premise that we're operating from is that, if you're paying for services from somebody, that is different than if you're reimbursing them for gas that they use to, run to the store because you were at an event and they needed to go pick. If you did that, I don't know. I guess I don't know how much reimbursement actually happens. I don't think a ton anymore, because it's the volunteer activities are mostly very clearly not contributions, and there's lots of reasons why you wouldn't want to spend your money on that. So the idea here was to try to find a way to, again, not deal with the issue we're trying to deal with, which is the big payment to a spouse or spouse equivalent or house. For example, there are all kinds of ways in which you can share living expenses, right? There's not just even the relationship. This would mean if your son, who is a political consultant, if you all are living together and sharing your expenses together, right? That counts, right? So that's the bulk of what we're trying to get at. So I guess if your real question, I think I understand the question to be, does this exception eat the rule because it allows for reimbursement? It would still have to be I think from my perspective, we think that it still have to it still has to be reasonable expenses otherwise permitted under the act. So it has to be a reimbursable expense under the act of the rules, and it has to be reasonable. So that is a thing we can assess. We audit for that. We can say, an auditor can say, your reimbursement of someone for going to pick up pizza, let's say the pizza costs $10 and you reimburse them for $30, right? That's why we think it's okay, because we think that it has to be a reimbursement otherwise allowed. It has to be reasonable, and that, we hope, is clear enough to say that that's distinguishable from a payment of, thousands of dollars for campaign services. So could it be clearer? I mean, I'm not saying it couldn't be. I mean, it could be, and I mean, I'm certain that that's true. But I'm hopeful that the language is sufficiently clear to put folks on notice about that what's in and what's out. I mean,
Mr. Chairman, so I guess and it's really just for my understanding. I just want to
Sure.
make sure. So when I look then at the 5B, or I'm sorry, the F5B, so essentially, it's only reimbursement to candidate spouse. So let's just focus on candidate spouse.
Right.
So, because that's defined under family member, and currently they under F4 would be allowed to have the provisions of goods and services as long as it didn't exceed the fair market value, they could be paid. But now they will not be a candidate spouse.
correct.
Okay. I think I just wanted to make sure that I understood how that was going to work.
Right. No, I mean, yeah, so Mr. Chairman, Commissioner Werther, right. So we wanted to carve out spouses and people who you're sharing your household expenses to from the family member rule. The reason we're doing it with the notwithstanding clause is because spouse is included in family members. And we thought it was easier to do it this way. It may not be, but I mean, we thought at least it would be easier to do that rather than to go in and tinker with the family member definition, because the family member definition gets into who can give money, and there's a bunch of other things that hinge off of that. So potentially.
Commissioner Payton.
So I would just ask that when we're giving these people classes on doing this, that we have a series of proper examples and a series of illegal examples,
Sure.
so that we can address this with these people, so we don't have so many people coming for penalties and so on. I hate doing the penalties, but
Right.
and the more black and white it is the easier for us to do. But in their minds,
Right.
so that we can go back and say, look, we showed you these two examples,
Right.
and you were in the class,
Right.
you signed off on this. So now, and now you're pulling this.
Right.
So I just think that if we did something concrete like that,
Yeah.
so we could try to make it more black and white to them,
Yes.
then I think it'll make all of our lives easier. And then the public will
Sure.
think that everything's on the up and up, which is a lot of this is what the public thinks about politics in elections, because we hear all these extraneous things about how stuff is not on the up and up.
Any other comments or questions on this issue for Tom?
Mr. Chairman, I did have,
Commissioner
I guess, at least one. And as part of what Commissioner Payton is saying, I think, and I recently had to do a presentation explaining what notwithstanding clauses mean. So maybe I'm just really sensitive to this right now. When I think someone who is looking at the funding reads F4, they may think that they're able to do something that is prohibited under F5, but that's to that clarity, right? Of making sure that they understand. And I don't know if it's helpful and maybe it's too redundant, but if we could put an F4, like except as provided in subsection 5, something to give them a clue that, oh, wait, it says you can do this, but there is
Yeah.
actually a different prohibition.
Sure. Yeah, that's so you would I'm sorry, Mr. Chairman. So would you put that something like in for like an additional line that says something like for or do we want to put the signal in F4 or F5? Because I don't have any problem with doing
Yeah,
that.
Mr. Chairman, Tom, I was thinking in F4,
Yeah.
sort of except as provided in, subsection 5 of this section, or however we want to
Right.
word that, and then you
leave the
leave everything else.
leave the notwithstanding.
Correct.
Yeah, yeah,
Yes.
okay. I'm
So then it gives like a
yes.
clue that there's actually another provision they need to look
Yes, I certainly I'm putting that.
Any other comments or questions from members of the commission?
Mr. Chairman, I have some questions.
Yes, Commissioner Crump.
Thank you, Chairman. Director Collins, do these proposed restrictions exist for traditional candidates at present?
Not that I know of, no.
Okay. And we presently have a big part of what our commission does and staff is we have an audit system to look for inappropriate expenditures, right?
Correct.
Okay. In doing just kind of a quick search online about some of this stuff, I noticed a couple of interesting things that there's a lot of variables that can go into this sort of action and analysis. For example, the FEC, I think just recently, it may have just been last year, allows non-incumbent candidates for federal office, like Congress, to pay themselves a salary. And they did that because they believe that creates more diversity and more access to office for less wealthy people. And I believe, if I'm not mistaken, if Connecticut is also a clean elections participating state, they have this type of restriction and they made it for any family member. And they have a full chart that lays out all of the people that you could not do this. So I'm just saying there's a lot of ways this could be sliced and diced if that's what we chose to do. You've proposed one. I'm not a big fan of this, as I think I mentioned during our last commission meeting, and I think I'm concerned because I think there could be quite a few appropriate and appropriate expenses by a candidate paying, for example, their spouse, who might be a printer, who might be a consultant, who might be an accountant. And all of a sudden now we have this blanket prohibition on paying them for their services, whereas that they might have been getting, great services at a great price. Now they have to go, out on the market, if you will. And so to have this blanket prohibition because of potential inappropriate expenses or situations, I think is sort of throwing the baby out with the bathwater, to use that phrase. And I think it's harmful, and traditional candidates don't have these restrictions, and I think it's harmful to clean elections candidates to place these on them. So I think we have an audit system in place to watch for inappropriate things where it looks that overpayments have been made and things like that. So I wanted to share those thoughts.
Thank you, Commissioner. Tom?
Mr. Chairman, Commissioner, I think I certainly think that that's all reasonable, and I, as a factual matter, I certainly agree with you. For purposes of discussion, at least, right, which is what this is. What we will do, just to sort of put this in some procedural context, if you were to approve this for public comment, we would publish a notice in the Administrative Register, and we would have a public comment period of at least 60 days, and then we'd get comment, and then would come back. from my point of view in where to start, we definitely have. I think we have to do the recodification regardless. I think that is something that it just is going to keep clean. It's a cleanup issue unless we can find a better solution. But in the meantime, we have to start that process. With respect to the merits of the proposal, I mean, I think it sounds. I mean, you all have a discussion to have amongst yourselves as we get feedback about that. I mean, my purpose here is really to try to kick off the discussion and have a proposal that I think we could work with and that at least has some support with respect to other programs. But to your point, I mean, yeah, I mean, it is absolutely fair and within all of your discretion to determine what you think the best approach for the program is in terms of how clean candidates are treated versus other candidates. I certainly don't disagree with anything you said. We wanted to start from a place where we were trying to address the problem as we understand it, but we're not married as staff to this. I mean, that's your decision ultimately, and happy to, if there are other proposals that are better. Let me put it this way: we don't have to start public discussion today either. I mean, if there are other, we even put this on the agenda just in case, just to be clear to anybody who wanted to be here, that we might get directed to have additional research done on additional proposals. So we don't usually put in. So we wanted to make sure that everybody understood, the public would understand that that precisely what you're saying here, that we might have direction to look at other things. So I'm happy to take that direction, and it's really up to you all how you want to address that. I don't have a strong emotional commitment to the proposal. Although I did like my illustration. Anyway, that's about that. But yeah, but everything else, I take your point.
Mr. Chairman.
Commissioner Crump.
So Director Collins, on that point, since I've only been a member for a short while here, I'm just curious on the history of this. Did the commissioners ask you to come forward with this proposal?
No, we divined, if you will. I mean, from listening to the conversation we've had over the course of the last several meetings, that there was one discussion about a rule that's pending that will be up in November related to this problem that we had with several candidates stopping filing reports. Right, that was a problem we had come up with a number of candidates. That was our initial conversation. And during that process, I think leading up to the rule proposal we made there, and then in that process, we talked around this issue of how to address this issue of where the money goes, right? So there are two different issues. We made a choice as staff, the first run through, to just focus on the reports. And so we have a rule that will come back to you in November that proposes to create a more put more teeth in. If you stop reporting once you have been funded, right, we will treat that more aggressively on the front end. So and as part of that discussion, and then the discussion last month we had around the enforcement itself, this is initiated by me, taking the input that I've heard from everybody over the course of the meetings we've had, to try to address what I take to be a real policy issue that the commission, that as a group, there's interest in. So I mean, in that sense, when I say on an emotional commitment to this, what I mean is that what I think we're obligated to do, what we try to do as staff members, is hear what you all are saying in the meetings, and try to anticipate what policy direction you might be wanting to move in, and tee that up for a discussion so you all can make decisions about it.
So, Tom, let me ask you one other question before we just talk about what to do. There's been discussion um, nationally and statewide about security
Sure.
for candidates. Is security a reimbursable expense under our rules now?
Uh, yeah, to the extent, yeah. So, Mr. Chairman, uh, yes. So this is about what you can't do.
Yeah.
What you can do is things that are direct campaign expenses. And so, the test we would apply as we would for any number of expenses would be, whether or not that security cost is associated with the campaign and reasonable and therefore appropriate. So yeah. So we believe that security costs are, there's no express authorization for security costs, but we believe that the authorizations that exist for what you can spend money on would include security costs already.
And that would include things like security upgrades to a residence as well as uh, personal security.
Um,
And do you feel like we should spell that out as I think the state has? and
Well-
the FEC has.
well, so the Secretary of State's office and the FEC have said slightly different things. The FEC has said something I think very similar to what I've said, which is that you have to be able to show a nexus between what the campaign and the security costs you have. Now, if there's a reason why your residential upgrades have a nexus to the campaign, let's say that's your campaign headquarters or you're doing events at your home or et cetera, there is an argument there. And I think we would look at that seriously. What this Secretary of State's office has said is something a little bit different. They have said two things. One, they're not going to look at a complaint relates to security and spending campaign money, period. So they don't care. They're not there, and that's not necessarily a statement of law. That's a statement of enforcement approach, if that makes any sense, right? They're saying, don't bring those complaints here. We don't want to hear about it. And then they say in the statement something to the effect that paying for security is part and parcel of every campaign, and therefore security expenses, if you're a candidate, are all expenditures. That has its own complicating factor in of itself, because expenditures, if it's an expenditure, it can't be made by a company. It can't be made over $5,500 for a statewide elected or for as an in-kind contribution. So if they mean what they say there, so those are conflicting things. In other words, one thing says we're not, as a policy matter, we're not going to look at these complaints, but as a legal matter, these are all expenditures inherently. If they're all inherently expenditures, that actually makes it harder, if they mean that, and I'm not sure they do. If they mean that, that actually makes it harder for traditional candidates to get that security paid for, because it all has to be on the books. It all has to be from appropriate source at an appropriate amount of money. And that actually makes life more complicated. So I think the where the secretary comes out that matters for present purposes is we're not going to look at these at all. And I think that's why within our existing context, to reference Commissioner Crump's point about the audits, if somebody has an expense for security that we can look at and we would scrutinize it, we would obviously take into account the fact that the enforcement position of the secretary is we don't care about those complaints, right? And we would look at it in view of that. But if we start to nail down, if we were to say that, for example, this is an expenditure that must be paid with clean money, then it's actually making it harder for clean candidates, because if it's not campaign, the clean candidates can get the money from other places. It's not an expenditure. Because we only deal with expenditure, contributions and expenditures. So I know that's a complicated answer, but what it's trying to get at is our approach, which, this does really reflect what Commissioner Crump is saying about this issue, is our approach generally is we look at, are you as a candidate making a reasonable business decision with public money and that can withstand scrutiny of our audit. That's our way of looking at it.
Okay. So, Tom, correct me on this. If it seems like we can go one of a number of different directions. We can say we will circulate this as amended with the language that you and Commissioner Werther agreed upon. We can circulate it. What we can say we want to discuss it more.
Yeah.
Commissioner Crump brought up a couple of concerns. What would be the best guidance to you to where we go from here?
Well, Mr. Chairman, I think a couple things. I think I'm happy to, separately get together with Commissioner Crump and we could talk about what we might better hone in on the issue to make sure that we have something to advance that discussion at an additional meeting, and I would happy to do that. For present purposes, though, my recommendation would be, in part because I do want to get the process of fixing this codification issue done. I think it would be good to move ahead with this. Now, that said, another way you could structure it to address Commissioner, and this is you all have to decide this, is you could advanced proposed 702F except 5, right? So the way 5 is written, you can excise it and everything else is fine. You just get what was previously codified, what we think, in, right? So so to sort of line this up, I think with respect to making sure that I understand and appropriately advising everybody and assisting everybody, I can talk to Commissioner Crump if he's interested. About what we might do to coordinate that. For discussion purposes and what we advance, the choice, it seems to me, that the four of you have is, do you do proposed 702F 1 through 4, or do you do proposed 702F 1 through 5 with the additional language, except as provided, the additional language we talked about with Commissioner Werther. So that's, to me, in just hearing what you all are saying, that to me is the choice. 702F 1 through 4 is the status quo. We are recapitulating the status quo and making sure that we are fixing this codification glitch. Adding 5, that's the new stuff, and this is the beauty of the notwithstanding clause. People, is that it is like a pod. You can eject it, and the rest of the language stays the same. So that, to me, based on listening to all of you talk about this, that's really the question right now, is whether or not you want to, if you're not at a consensus, and you'll have to vote on this obviously, but if you're not at a consensus around what to do with F5, there's no, you could take that off here, and we don't lose anything in F1 through 4 that's not an existing rule.
Okay. Commissioner Werther, do you want to make a motion? And I think we've got to have some understanding that when this comes back to us, or at some future point, we've got to do something to address Commissioner Crump's concerns, which I think are I agree with a lot of
Right.
it.
Well,
Well, Mr. Chairman, I guess before I make a motion, I understand the concerns as well from Commissioner Crump. So I'm fine excising F5 at the moment, but I think there were legitimate concerns of why this was brought forward, and I'm still not comfortable sort of having a clean candidate basically pay somebody, clean money, as what's happened recently. So I do still feel like we need to address it at some point, but I'm fine with that being reworked if Tom can talk with Commissioner Crump. So I mean, I'm fine with excising F5 for the moment to at least get the current rule recodified. So I'm happy to make that motion. So I just move to, I guess, approve or no?
To circulate for public comment, 702 F134.
What Tom said.
Well, I'm
That's the motion.
Okay, so
Okay.
Commissioner Werther has moved that we circulate for public comment.
R2-20-702 F through 4, excising subsection F5.
Is there a second to that?
I'll second that.
Okay, thank you, Commissioner Crump. So it's been moved and seconded that we, I'm losing all my notes here, that we circulate for public comment R2-20-702 with the exception of F5. And I will call the roll on that motion. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.
chair votes aye. It's approved 4-0. That was painful. Thank you. Item 5, discussion and possible action on proposed conciliation agreement in MUR 25-02, Ana Abatia, 2024 legislative candidate. The executive director has recommended a conciliation agreement regarding Representative Abatia. Tom will present his recommendation and take questions. Tom?
Yeah, Mr. Chairman, Commissioners, and Representative Abetia is here. I just want to say up front, she is appearing via Zoom. I expressly said that was the best idea. She has childcare issues today, and coming down here with sitting through that discussion, as edifying as it would have been for a kid, I think was probably, so that's on me. That's my recommendation to her. Anyways, we are back with the with a altered conciliation agreement. The major shift in terms is the stipulated fine is significantly higher. It is $10,000. Everything else is the same, so I don't have much to add beyond what I said last time, and as I mentioned, the representatives here or via Zoom and available, but I believe that that this agreement has sufficient both financial penalties, the repayment order incorporated into it that for her, and also has a strong default provision that taken together, make this an appropriate and reasonable public settlement.
And I want to point out that it also includes a provision that she agrees not to seek or accept clean elections funding in any other future election. Are there any comments or questions from any member of the commission on this proposed conciliation agreement? Representative Abatia, did you want to speak?
Hello, can you hear me?
Yes, we can.
Oh, thank you. Well, for one, I want to apologize for not being in person. I have a 2-year-old, and I have been on Zoom with you for most of this meeting, and it really would have been painful for all of us with my 2-year-old running around in person. But I do not have childcare at the moment. Um, I just want to thank you all for the option to have Zoom available, because it does work out for me and for my daughter. So one, thank you. Two, I just want to reiterate that I acknowledge that I wasn't responsible during the election by reporting, and I wasn't doing my part as far as having communication with Clean Elections, even after so. And yeah, I just want to acknowledge my lack of doing so and take accountability for that. So and since then I have been in communication with Thomas, and just trying to, you know, figure out where we go from here. So I just want to thank you all for giving me the opportunity to be in this process. I know it sucks for you all, and I apologize for that. But again, I want to make sure that you guys are aware that I am apologetic of the situation.
Thank you, Representative. No apologies necessary for attending on Zoom. We're happy to accommodate you. Any comments or questions from members of the commission? Is there a motion to accept this conciliation agreement?
Mr. Chairman, I move to approve the proposed conciliation agreement in MUR 25-02.
Thank you, Commissioner Werther. Is there a second?
No, second.
It's been moved and seconded that we approve the conciliation agreement in MUR 25-02. I'll call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.
Chair votes aye. The agreement is approved 4-0. Thank you for your time, Representative Apatia. Item 6, discussion possible action on proposed conciliation agreement in MUR 24-05 Frank Roberts. Tom?
Yes. Commissioners, Mr. Chairman, Commissioners, and I think I'm not sure. I don't believe Mr. Roberts is going to be here, but he did submit a written statement. I think that so this candidate's situation is slightly different. They filed reports, but the reports were, kind of were woefully incomplete. We were able to get the candidate engaged with our auditors. I did file a complaint to prompt that. I think that's the order of we did that in. Ahead of that, the process has been slow but steady, and so we are now at a place. You have the audit report. The audit report, demonstrates that there's no substantial issues with the actual expenditures. The candidate has agreed to hear. Again, there's a distinction here because of the responsiveness and because there were reports, albeit reports that were not sufficient. The thought here is that we would have this candidate essentially on a form of probation, where they're filing additional reports with staff so that we can check in with them, rather in addition to the reports they're required to file, and that there be a fine there as well. So that is we think that we are trying, as we talk. I spent a lot of time on this last time. I don't want to recapitulate all the thoughts we try to put into this, but what we're trying to do here is find a fair outcome that takes into account, the conduct differences among not just this case, but not just this set of cases this year, but the cases over time. The last time we had a similar, I looked at this, and in fact, it's the very document I used to develop the conciliation. The last time we had a reporting issue like this, so not a non-file, but a insufficient file, the fine was about $1,000. So we think a $1,500 fine is appropriate. And like I said, this is a novel approach for us. Again, what we're trying to do here, both with how we've gone about with Representative Betia in terms of her not running clean, what we're doing here with Roberts is another novel approach, which is you're going to do this again because he is going to run clean again. We are going to say you've got to provide us additional reports so that we know what you're doing, and we think that will be now that's a little more work for us, but we think in the long run it's a better it's an appropriate approach. We think had we just switched over and said, okay, pay the fine and we'll just go on without any additional monitoring, I think that would have been that would have been too difficult for us to that would have left this hanging, right? We really wanted to have that additional monitoring, and so that's what we propose here, and we do think that the candidate recognizes that. We think that again, attendance here. Most of the candidates have other things, and our schedule's fixed. I don't take anything. I personally, have not been. I thought having the letter would be sufficient. So I'm not as concerned about that. Although I know it's a concern for commissioners. So that's it. I guess I'll leave it there. We think this is a fair resolution that consistent with in other settlements we've done on the issue of not failure to file, but failure to sufficiently report within the filing.
Thank you, Tom. Are there any questions or comments from members of the commission?
I guess I have a question,
Commissioner
comment.
Payton?
We haven't had these issues that I can remember in the 7 or 8 years that I've been doing this. Is there some confusion in the classes that they don't understand that they have responsibilities to turn stuff in at a person? I don't understand what's going on here, I guess.
Mr. Chairman, Commissioner, the rule we have coming up in November for final approval is a rule that says that if you didn't understand this going through, you didn't understand it when you read it in the Secretary of State's materials, and you didn't understand it when you read it in our materials, and you didn't understand it when Mike told you, and you didn't understand any of it, if you don't file a report within 5 days after when you have a report due and you've been funded, we're going to initiate a repayment order. So that's the rule that'll be up for vote in November. So if there's some gap we think that new rule, which says that when you get the notice from the Secretary of State's office that says you're late, you'll also get a notice from us that says, and we're going to ask for the money back. That should be a strong incentive for a clean candidate to file promptly, because it'll be on the same calendar. So that's our goal. But that's the best way we can think of to try to put some teeth in beyond the fines that are there and stuff. We think because the issue here is to your point is to be on the front end of this, not on the back end of this. We have not figured out any common. There are 2 candidates who ran together, but their cases are kind of separate. There are 4 candidates altogether in this boat. There are 4 different people. They're from different parts of the state. They're from different districts. They're from different backgrounds. They're from different parties. There is no common thread that we've been able to find. We've had situations before where, and this is true. We have had situations before where we had one treasurer do the same wrong thing in 5 different candidate matters, right? And then we can say, well, that's this, right? But we have not been able to find anything that would relate these together other than, other than, just a, just I don't have, so I don't have an answer. But we do think that the rule going forward, the rule we have up in November is designed to address that. We hope.
Mr. Chairman?
Commissioner Werther.
Tom, I just wanted to get clarification about the extra report. So on page 2 and under 2B, so it doesn't look like that would be a reason for default if he stopped doing his monthly reports. And then I also just wanted to clarify, because on the last page on section 21, it says that these matters are terminated once completion of the requirements. So are we thinking completion of the requirements is going to just be extended because of that reporting requirement, or is it
Let me look
when
at
the fine
let me look at the
is due?
default. Hmm. Well, I mean, I would say this. Default meaning, would we collect the fines if they failed to? If default defined as would we go after more collection if he failed to find the report? That's right. We would not. We might. I mean, we could probably demand specific performance. We could, we could. I mean, we could do some. I mean, they would be in breach of contract. There's the difference being that, that the because it's not a default, at least as I understand it, it would not mean we would immediately accelerate to an additional fine. But I don't know that we would want to do that anyways. In other words, but they would be in breach, which, what does that mean? In this case, it would mean that the breach of the contract would mean that the contract is off and we could pursue that. It would just be, we wouldn't immediately accelerate. That's how I understand that. If that, in other words, there are degrees of an issue here. I'm fairly confident that he's going to do this. If he doesn't, he's in breach. And if he's in breach, then the contract is breached, and we just would not accelerate the fines. We would have a process. But I think that recognizes the difference between the financial and the reporting issue. So I don't know. It's your decision. Obviously, I think that's a distinction with a difference.
Mr. Chairman, so Tom, I'm just seeking
Yeah.
clarification.
No, of course. No, I know.
Yeah, especially on the last. So let's say he pays all the fines. He pays the $1,500. He's done. Is this agreement then terminated, or is he still going to be required to report monthly?
He would not have completed the requirements of the agreement.
Okay.
It is perfectly reasonable. However, if you would like to add in language, the way we could do this is, if in paragraph 7 we could add in language that says any of the following, and then add E, fails to comply with any other provision of this agreement, and then authorize me to make that settlement with him with that term. I mean, and I would say this is the deal. And then it's up to him if he wants to, if that's a hang up for him. I suspect it's not, and I think that will be fine. And because it's a discreet, I mean, it seems like it'd be discreet. I'd be happy to take that back as a counter offer essentially, and say I'm authorized to sign this under this condition, and that's how we would do it.
I mean, Mr. Chairman, it's more just for clarity. So, because if obviously, he doesn't file his reports, I just don't want us to be in a weird
Right.
limbo of, well, he's not following it, but yet the fine's paid. And so I would be open to adding that subsection E to 7 if everybody else is okay with that.
Are there any other comments? Commissioner Werther, do you want to make a motion that will include your addition?
Yeah, Mr. Chairman, I move to approve the proposed conciliation agreement in MUR 24-05 with the addition of a new subsection E under 7 on page 3 that adds under the default that if the Mr. Roberts fails to comply with any other provision of this agreement.
Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we approve the conciliation agreement MUR 24-05 with an addition as spelled out by Commissioner Werther, adding a section E to 7 on page 3. I will call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump.
Aye.
Chair votes aye. The motion is approved 4-0. Item 7, public comment. This is the time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter, rescheduling it for further consideration, or responding to criticism. Please limit your comments to no more than 2 minutes. Does any member of the public wish to make comments at this time? There's no one here. Anyone on Zoom wish to make comments? Hearing none. Public may also submit comments by email at ccec@azcleanelections.gov. Item 8, adjournment. At this time, I would entertain a motion to adjourn.
Mr. Chair, I move to adjourn.
Thank you, Commissioner Werther. Is there a second?
I'll second.
I will call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump.
Aye.
Chair votes aye. We are adjourned. Thank you.